Well, good evening, everyone. I'd like to welcome you to this special meeting of the Cunningham Town Board. It's Monday, March 27th, 2023. Will the clerk please call the roll?
Ms. Wu,
Here.
Mr. Evans,
Here.
Ms. Hersey,
Here.
Ms. Colasetti,
Here.
Ms. Bishop, Ms. Wilkin,
Here.
Mr. Quisenberry,
Here.
Mayor Marlin,
Here.
Ms. Chenoweth,
Present.
Next item on the agenda is public input. If anyone wishes to address the Cunningham Town Board, please step up to the microphone and state your name for the record. None. We'll move on to resolution number T 2023-03-23R, which is a resolution authorizing certain individuals to sign checks for Cunningham Township.
This is a housekeeping item to essentially remove the former assessor, Wayne Williams, from the bank account and to add Urbana. So we'd like to be able to move forward so that we can do due diligence with the finances.
Any questions for Danielle? Grace?
Thanks. Just had a quick one. Is that the only change here from the previous one is just switching Wayne for Ivana?
Correct.
Okay, thank you.
Is there a motion?
I'll move approval of resolution number T-2023-03-023R, a resolution authorizing certain individuals to sign checks for Cunningham Township.
Second.
Moved by Chandra, seconded by Mary Alice. Discussion? Will the clerk please call the roll?
Ms. Wu,
Yes.
Mr. Evans,
Yes.
Ms. Hersey,
Yes.
Ms. Colasetti,
Yes.
Ms. Bishop,
Yes.
Ms. Wilkin,
Yes.
Quisenberry.
Yes.
That motion passes. Next item is resolution number T 2023-03-024R, which is a resolution authorizing the supervisor to sign a memorandum of agreement with the Housing Authority of Champaign County and the Urbana School District for the sponsor-based voucher program for family service providers.
So this is a long-awaited announcement. It was voted on by the Housing Authority on Thursday, and I noticed in that resolution that it could start on the 23rd. Right now, we have families without access to vouchers, so I wanted to bring this to you before the next meeting because it means we can speed up voucher provision for families by 2 weeks. So essentially, what the Housing Authority has done is to put in their Move to Work program sponsor-based vouchers, and they prioritized and had an RFP for organizations to submit to be the referring agencies for vouchers. They asked organizations working with families, and these are specifically vouchers for people with children, for households with children. So essentially, what this will do is, given that COVID vouchers for homeless individuals are limited and running out, this will allow us to continue to move families into project-based housing vouchers or use vouchers to house them at subsidized rates. So we are partnering with the Housing Authority and USD 116 for this. So far, we've helped 50 households apply and supported, so we've helped 50 households with children apply. We've actually helped over 130 households apply. And so we're building on this partnership and our partnership in the school district, identifying families that are housing insecure and homeless to help them apply for vouchers and access those vouchers. So this is kind of a dream come true, and with your affirmation, we can move forward and start recommending people who are working with families who are working with for vouchers.
Any questions for Danielle? Is there a motion?
I'll move resolution number T 2023-03024R, resolution authorizing the supervisor to sign a memorandum of agreement with the Housing Authority of Champaign County, the Urbana School District 116, for a sponsor-based voucher program for family service providers.
I'll second.
Moved by Mary Alice, seconded by James. Further discussion? Will the clerk please call the roll?
Ms. Wu,
Yes.
Mr. Evans,
Yes.
Ms. Hersey,
Yes.
Ms. Colasetti,
Yes.
Ms. Bishop,
Yes.
Ms. Wilkin,
Yes.
Mr. Quisenberry.
Yes.
That motion passes. Last action item is the Cunningham Township Annual Town Meeting Agenda for April 11th, 2023.
So we're required to have an annual meeting. You will see the agenda is basically what it has been in the past. From now on, I want to have a property disposition item. So we had that last year. We ended up not using it. So we're surveying our property to see if anything needs to be disposed of or given away. And if we do, then we'll present those at the annual meeting.
Any questions on this? Yes, Chris?
Danielle, is this the meeting where citizens can propose a referendum of any kind?
Yes, but there's a deadline to propose that referendum, and I defer to the clerk's office. But I'm not sure if that deadline is passed.
Yes, it has.
Okay, thank you.
Questions? Do we need a vote on this? No?
Oh, wait, no.
Voice vote will do this.
Okay. All those in favor of the annual meeting to be Tuesday, April 11th, 2023, please say aye.
Aye.
All those opposed? Okay. We'll be at 6 o'clock, April 11th. Reports of officers.
Yeah, so I put this item on the agenda partly in just to, so I'd be able to give an update. I wanted to invite Esther Pat of the tenant union to step forward to the, and she and I will be presenting, and I expect Ruth Wyman, who is the attorney for the tenant union, to join us momentarily. So, last week, City of Urbana Human Rights and Equity Officer Carla Boyd and City Attorney David Wesner, representing their own position as well as that of their supervisors, Mayor Diane Marlin and Chief Administrative Officer Carol Mitten, gave a presentation to the Urbana City Council claiming that the Human Rights Ordinance, which has banned housing discrimination based on source of income, is largely unenforceable, and that landlord participation in the Housing Choice Voucher Program is voluntary. The slide I will quote from is, it's the city's position that we do not currently have the legal authority to compel a landlord to participate in the voluntary, underlined Section 8, or TBRA voucher programs. This is false. It is false. Not only were many of their statements factually inaccurate, stating this poorly researched and ill-considered position publicly is extremely damaging to the public interest. It undermines the work of Township and every service provider working with low-income residents in the county. It messages false information to the business community, signaling them that it is open season for discrimination in Urbana. I want you to remember that the people who are hurt most by rejecting vouchers are those who rely on them the most: children, people with disabilities, and seniors. I am speaking tonight to correct the public record. If this had been a private conversation, I would have been able to give this information before. But I am part of a fair housing coalition. It includes representatives from the city, the township, along with the continuum of service providers, Regional Plan Commission, the Housing Authority of Champaign County, and the tenant union, as well as state organizations Hope Fair Housing and Housing Action Illinois. We have been coordinating for over a year on how to address housing discrimination. Many of us worked with State Representative Carol Ammons and the late Senator Scott Bennett, who were co-sponsors and champions of the Fair Housing Bill that now prohibits source of income discrimination across the state. This group has had active discussion and a recent coalition email thread to prepare for our fair housing workshops next week. There's been no mention on this thread of the city's position, this public presentation that happened last Monday, nor any questions to the lawyers or the experts on this thread. Carla Boyd stated last week, between Attorney Wesner and myself, we have talked to many people. Even though many of these people believe that state law compels the landlords to participate in this voluntary program, none were willing to provide a legal opinion to support this view. No representatives from Cunningham Township or the tenant union, who together have spearheaded the Fair Housing Coalition, have ever been asked to provide a legal opinion. So such a declaration was at best premature and at worst harmful to the public interest. I'm going to lay it out for you very clearly, and I will send this to you in email. Fiction. Vouchers are not a source of income. This is fiction. Fact. Vouchers as a source of income have been legally established in the city of Urbana since 1979, with a clarification by council when this was contested in 1996. In the Human Rights Ordinance, Chapter 12, Section 1237, and I quote, and I would encourage you to read the Human Rights Ordinance, because many of the things that were stated are in direct opposition to the language of your own ordinance. It is the intent of the city of Urbana in adopting this article to secure an end in the city to discrimination, including but not limited to discrimination by reason of race, color, creed, class, national origin, religion, sex, age, marital status, physical and mental disability, personal appearance, sexual preference, family responsibilities, matriculation, political affiliation, prior arrest or conviction record, or source of income, or any other discrimination based on categorizing or classifying a person rather than evaluating a person's unique qualifications relevant to an opportunity in housing, employment, credit, or access to public accommodation. I further read Section 1239, the definition of source of income. The point or form of the origin of legal gains of income accruing to a person in a stated period of time from an occupation, profession, or activity, from any contract, agreement, or settlement, from federal, state, or local payments, including Section 8 or any other rent subsidy or rental assistance program, from court-ordered payments or payments received as gifts, bequests, annuities, or life insurance policies. That's your state, that's your city code. The state of Illinois, Resolution 2007-75, the source of income definition in this borrows directly from the definition in the ordinance for the city of Urbana. It is exactly the same. They have been enforcing their human rights ordinance protection for voucher holders for decades. Source of income means the lawful manner by which an individual supports himself or herself and his or her dependents. If there's any question as to whether or not this is a source of income, we simply need to look at the 2004 appellate court case, Inez versus Sullivan Lackey. The court found that Section 8 vouchers are lawful means of support under the above definition. The court ruled against the landlord that they were discriminating against the applicant by denying her tenancy based on her source of income. This is literally 9 years ago. Second fiction, participation in the voucher program is voluntary. I listened to the text of your meeting last week, this morning, and this word was used over a dozen times. The fact is that since 1979, it has been illegal in the city of Urbana to discriminate based on source of income. In last week's presentation, it was stated that HUD considers the Housing Choice Voucher Program a voluntary program. This is true outside of the state of Illinois or any jurisdiction where a source of income discrimination is not prohibited. This argument is like saying that an employer in Urbana or Champaign can deny me a job because I'm a lesbian, because on the federal level, there is no protection against employment discrimination for LGBTQ residents. We are in Urbana and we are in the state of Illinois. It is not an optional program in these two jurisdictions. Third fiction, an application is required to enforce a source of income protection. Let me just consult common sense for a moment, and then I will read your ordinance. We don't rent to blacks. Is that not an actionable statement? Can you state something? Can you put it in writing to the township, which they have done, and I've sent it to the mayor and the human rights ordinance officer in writing, saying that we do not either take people with felony convictions, or we do not accept source of income. It was stated that you have to submit an application, and that it's very difficult to enforce without that. But reading from Section 1264, Housing and Commercial Space, from our own Human Rights Ordinance, makes it very clear there are 3 points. It is lawful unpracticed. It shall be an unlawful practice to do any of the following acts for a reason wholly or partially based on discrimination. We have now defined discrimination. We know source of income is a kind of discrimination. We're now going to points 1, 5, and 11. It is illegal to refuse to negotiate for, enter into, or perform any sale, exchange, or lease of any real property, or to require different terms for such transaction, or to represent falsely that an interest in real property is not available for inspection purpose, purchase, sale, exchange, lease, or occupancy when it is in fact so available. It is illegal to make, print, or publish, to cause or be made, printed, or published any notice, statement, or advertisement with respect to a transaction or proposed transaction in real property or financing related thereto, which notice, statement, or advertisement indicates or attempts to indicate any preference or limitation. Under that statement, dozens of landlords are discriminating because they already have put on their applications, and I have sent this to you. We have created a report about it, talking about children are not allowed, non-students, we only rent to students, we don't rent to people with criminal convictions, we don't take housing vouchers, we don't participate in a housing choice voucher program. And the third, Section 11, to refuse to negotiate for, enter into, or perform any sale, exchange, or lease of any real property because of discrimination against any party to the transaction, any member of the family of any such party, any person using or occupying or intending to use or occupy the real property, or any person using or occupying any real property in the area in which such real property is located. We have an excellent ordinance. It's been on the books for a long time. It has been crafted over many, many decades. The fact of the matter is that the city of Urbana is and has been reluctant and sometimes outright refused to enforce fair housing law in the city of Urbana. And they are now saying they're not able to enforce fair housing law and that it is a voluntary program, which is not true under local or state law. In addition, it is harmful for the city of Urbana to state that it is a voluntary program in public, for it to be on the public record that city staff state this. It emboldens landlords who otherwise would wish to follow the law to discriminate against participants based on source of income. It makes my job and the job of every single person in my office 10, 20 times harder for this misinformation to be distributed to the public. The law is a community pact. It affects not only what is allowed, but also the culture. Most landlords we know want to comply with the law. And when the city, a public entity, signals that they no longer need to comply to it, the consequences can be devastating. And they will not be devastating to most of the people sitting around this board. They'll be devastating to people that you very rarely see or talk to or hear from. But they are the people that we work with every single day at the township. And they consistently tell us how difficult it is and how they are turned away time and again based on source of income. And when I am asked to take a case to the city, I do at times. Many times these are homeless residents, and they are residents who are simply trying to find a place. They do not have time to go through a lengthy, months-long process of standing up for their rights. Instead, they are trying to look for a home, and I can't argue against that. And so what I want is I want this council to get an independent legal opinion. I want you to hold staff accountable for misinformation. 4 council direct staff, in addition to the mayor. The mayor is not the only chief at the table. So 4 people need to speak up. And I need you to come to meetings and speak to fair housing. Next week, I will send you the information. I believe Esther has also sent it to you. You can come to one of 3 meetings and you will be able to speak to legal experts on this case and get a different opinion. And with that, I would like to pass it over to Esther Paddens, the director of the tenant union, served on city council for a number of years and has direct experience with many of the pieces of history behind this. Thank you, Esther.
Turn on the mic too, and turn on the mic and
I'm sorry, okay.
pull it forward.
Thank you. Yeah. It's my habit to support the mask wearing wherever people are, so I don't want to offend anyone. I want to explain to you a little bit of just about renting that I think gets, a lot of people don't even understand basics about how the process works of people renting an apartment and how that matches with Section 8. And I'm going to be quick about it. If a landlord's listing an apartment and I'm shopping, I'm going to call and ask to see it. There are some landlords who will not show the exact unit. Some apartment complexes won't. They want to show you a model. As long as they won't show anyone the exact unit, that's totally legal. In fact, I said this to Danielle earlier, and clients are always shocked when I say it's the tenant union, but a landlord can do anything they want as long as it's not prohibited by law. And one thing that's prohibited by law is discrimination, so a landlord can have any process they want for how they lease as long as they apply it to everyone equally. And if a landlord doesn't want to show an exact unit and wants you to sign a lease, if they can get someone to sign without seeing it, that's what happens. Most landlords will show a unit to a prospective tenant because most tenants won't sign without seeing it. If I went to view an apartment, and we use the word view, I would conduct an inspection that is more comprehensive than the housing quality standards inspection conducted by the city, by the housing authority. And I'm not going to presume, but I would bet anything that Mayor Marlin would do the same because she has owned rental property before. She knows what to look for. And I think most of you are now old enough that even though you're homeowners, most of you, if you were renting, you would check to make sure every single window has a lock on it and a screen, and you would open every window and make sure it stands open by itself and that it shuts and it fits properly in its frame. I'm not saying inspectors don't do that, but they check for the windows. I mean, and I don't want to make it sound like it's a light inspection, but this concept that opponents of fair housing put forward, that there is this onerous burden on a landlord to submit to an inspection. I'll describe a simple process. I call, I want to see the apartment, I go see it. A couple days later, I call and say, I think I want it, I'm going to come back. I can come back with my mom, or with my best friend Margie, or with a housing quality inspector. And the inspection is looking at things, looking at, is there evidence of leakage in the ceiling or at the baseboards? If you observe roaches, you write it down. Is there a smoke detector? If there's any gas, is there a carbon monoxide detector? Et cetera, et cetera. And when the inspector is done, if they find violations, they give a notice to the landlord that these violations have to be corrected before housing authority will accept this unit for rental. And if the landlord says, I don't want to do the repairs, it's over. And that's not unlawful discrimination. And they never send the report over to the city to get the city to cite the violations. So a prospective tenant and somebody hired by the housing authority are both aware of code violations in a rental property, and they walk away from it, and life goes on. What is a real burden to people with vouchers, and this is why there has been a nationwide movement and more than 50 states, cities, or counties have adopted laws like Urbana's and like the new state law, is because the way the market works excludes a lot of people with vouchers without discriminating. And the simplest thing, I'll go back to my example, I see an apartment advertised, I call, can I see it? I go see it, I think about it, I call them the very next day and say, I think I'm interested, sorry, it's already rented. And anytime, anybody, if I'm looking for a place and you're looking and you have a voucher and I don't, I am getting that place before you. For that matter, if I am willing to see it sign for it after one viewing and you want to come back with your mom or your best friend, I'm going to get it, you won't, because I'll get it first. And almost all landlords do rent on a first-come, first-served basis. There might be a misconception that if I have a voucher and I saw the place on Friday and I told the landlord I'm interested, that now the landlord has to stop showing the place to anyone because they're waiting on me. That is not true. Nothing requires the landlord to wait on anyone, unless the landlord's policy is the day someone says I want it, they won't show it to anyone else and then they put you first on the list. I personally don't know landlords who do that. Another biggie that really hurts people with Section 8, or here it's housing choice voucher, but hurts people with vouchers or tenant-based rent assistance, and you can confirm this yourself by just get online and shop for apartments yourself. Gobs and gobs of apartment listings. Go to landlords' websites, go to Craigslist, Zillow. And if you look at when they're available, almost anything available, and most anything advertised, not almost everything, a huge amount of it is available in August. And so when I'm looking for stuff, when we're looking for stuff for people with vouchers, we're looking for available now. And you can go to their website for, Westgate Apartments in Champaign, or Ramshaw Real Estate, or University Group, and they'll have, 50 apartments listed, and 47 will be available in August. And so we look for the available now. People with vouchers are only going to be able to get things that are available now. Whenever they are looking, is it on the market now? And there's also a complication from the Housing Authority that they will only inspect an unoccupied unit. The overwhelming majority of apartments in Champaign-Urbana rent months before a tenant moves in. So the total volume of apartments or houses that are left available to people with vouchers before we get to discrimination is a small percentage of the total market. And then it's very frustrating. This is the easiest way to prove discrimination. And I'm talking whether it's kids or disability or anything. If they tell you the place isn't available and 3 weeks later they're still showing it, that's how people catch this. That's how you catch race discrimination too, any discrimination. Mr. Evans asked me before the meeting, well, how do you prove discrimination? It's really hard. But as far as Section 8, or housing choice voucher, there are landlords who could completely refrain from discriminating and never rent to anyone with a voucher because they lease way far in advance. But when something is on the market and the landlord says, I won't take a voucher, the landlord is holding a unit vacant rather than renting it to someone because of that person's a demographic characteristic. And as Ms. Chenoweth pointed out, if a landlord said, I won't rent to you because you're black or because you have kids, and they're just going to hold the apartment, and then a month later they can find a white person without kids, that's discrimination. And it's just astounding to me that a brand new state law was passed in January, and already the city of Urbana has pronounced the law is unenforceable. Like, do you think the entire Illinois legislature, and who are filled with lawyers, and the Department of Human Rights, and the Chicago Human Relations Commission, and the dozen organizations statewide who are working this, they're all wrong, and the city of Urbana staff is right? I mean, seriously, that just isn't the case. And I came here tonight mainly in support of Ms. Chenoweth's point that what you did last week was just deplorable. I wish you had just privately decided you're not going to enforce the law. That's happened at least a dozen times since the law first passed around here, depending on the case or the respondent or who was working in city legal or whatever. But for you to announce, not just that you're not going to enforce the law, but you just gave credibility to every single landlord in town who wants to discriminate, to say blow off to everyone who works at the Township, Regional Planning Commission, Family Service, the homeless shelters, Champaign-Urbana 10 Union, the entire community of service providers in this town counts not on winning cases in court or winning hearings before the Human Relations Commission. We count on enforcing laws the way most laws are enforced. One, the majority of people comply because it's the law, and they will continue to comply unless you tell them they don't have to. And two, people who don't necessarily voluntarily comply back down quickly when they face a consequence. It is true, no law could ever force anyone to take a voucher, just like no law can force you to feed a parking meter, no law can force you to drive the speed limit. But if you break the law and you get caught, there's a penalty. And there is a penalty for landlords. Any property owner who is offering any housing to the public, you can discriminate your little heart out if you keep it private, but if you put a sign in the yard or post anything on the internet or you hand write an index card and push it, use a push pin to put it up on the bulletin board in the laundromat like in the old days, that is public offering it to the public. And as soon as you offer it to the public, you cannot discriminate at all in any way that is not based on the relevant qualifications for the opportunity in housing. And I want you to know, with every law, it works this way. The Urbana Landlord-Tenant Ordinance passed in January of 1994, And it didn't go into, it was affected, leases signed after that date, so it really didn't even go effect till the fall. I worked on campus at the time at the tenant union, and thousands of students came through that office shopping for apartments, and I was already hearing about how landlords in Urbana say we can't show it till the next day because they have to give 24 hours notice. And landlords were voluntarily, and the chambers were filled with landlords who were against it, but once the damn thing passed, they went ahead and complied. And when a landlord doesn't comply, I don't know if there have even been 5 people in 29 years who have sued a landlord under the Urbana Landlord-Tenant Ordinance. And there are several provisions in there where violation of the ordinance results in the tenant being entitled to double the amount of their monthly rent plus court costs and attorney's fees. But hardly anyone ever goes to court. All you have to do, there are still landlords to this day who violate tenants' privacy, but most tenants write a letter to the landlord saying, the law says I can sue you for 2 months' rent plus court costs and attorney's fees. Please don't do this again. And voila, landlords don't do it. I've worked at tenant union I don't do client service anymore since the COVID shutdown, but before that for 40 years. And I can't tell you how many landlords have given back damage deposit money, stopped violating their tenants' privacy, corrected building code property maintenance violations without ever even having an inspector walk in the door. When you present people with this is the law and this is the penalty, a whole lot comply. And that is what you stole from the children, senior citizens, and people with disabilities of Urbana last week when you announced that nobody should believe anyone who tells them that they can't refuse someone just on the basis of a voucher because City of Urbana says the law is invalid. And we are going to now, Ms. Chenoweth and I and the people we work with are going to have to do a great deal to put out the public word that the law is good and what you said was wrong. It would be really nice if Urbana would rethink this. And I know that as long as I've been here, the majority of city council members have supported this ordinance. But there has always been pushback from the administration, and I would hope that the council and the administration, Mayor Marlin, would get together and walk back the extreme incorrect information you announced last week so that those of us who are working to help low-income people get housing don't have one more barrier to climb, that being resistance from the city. Thank you very much.
Thank you, Esther. And if I could ask Ruth Wyman, as the supervisor's guest to the town board meeting, Ms. Wyman is the attorney for the tenant union, and I've requested, there was a statement that was said that there had been no legal opinion made on this, so I reached out to the attorney for the tenant union, and it sounds like there's an opinion that has been requested. Ms. Wyman.
My name is Ruth Wyman.
Could you make sure your microphone's on, please?
Thank you. My name is Ruth Wyman. I am the attorney for the Champaign-Urbana Tenant Union. I have my practice about a block away and have a general practice here in Champaign County as well. I've worked with the tenant union for about nearly 30 years, but now serve as legal counsel for the Champaign-Urbana Tenant Union. I'd be happy to work with legal counsel for the city of Urbana in making sure that it is clear and that counsel for the city, who I know work on many issues, not just issues about housing, but certainly many issues, to make sure that they understand the laws and are clear in being able to direct staff and any landlords with regard to the mandatory nature of the Human Rights Act, the landlord-tenant ordinance as well. I previously served on the city council in which we voted on and clarified issues with regard to the landlord-tenant ordinance, the human rights ordinance as well. And I intend to work to prepare a legal memorandum and want to make sure that it's clear to council members, to board members, and to staff and the mayor. I'm happy to help in preparing and gathering any information on issues with regard to human rights ordinance, with regard to enforcement, causes of action as well, to make sure that all of the residents of the city of Urbana, regardless of their source of income, have their legal rights protected. My office number is 217-239-1544. My office is located inside the downtown Urbana post office building, so do not hesitate to reach out to me if you have any questions, if you desire any other information, but I'll be working to prepare documentation and a memorandum for legal staff as well, just so that they have that background and information as well.
Thank you, Ruth.
Just for the record, I would like to state the city has no intention of dismantling our human rights ordinance or enforcing what's in place now. We were seeking clarification on the state law. We, in fact, received additional clarification today, and we'll be providing information to the council. But thank you. We'll be happy to work with you as well.
I appreciate. I look forward to continuing to work with the City of Urbana. It's even better than Bora Bora. So, thank you.
Wish we were in Bora Bora. But yes, thank you for the information. And we also will be attending the meetings next week that you're referring to. And I apologize for any anxiety last week's call. It was not intended to provoke anxiety or to increase uncertainty. Obviously it did, but we stand firm on opposing discrimination in the city of Urbana, but we were simply trying to get clarification on the state law. Grace.
Thanks. Thank you very much to the supervisor and our guest speakers for some more information on this. I really appreciate it. I wasn't here last week, but watching the presentation, I was definitely wondering some input from people who spoke tonight. So thank you for sharing with us. And I'm definitely in support of looking into this more, and I'll look forward to hearing what the state said and some other recommendations that we get to be sure that we can enforce this in a meaningful way. Thank you.
We've got a case in the works now, as a matter of fact. So, Jan.
Yeah, thank you for this information and taking the time. I think it's really important, and I think it's also important for our community members to hear. If you have questions, if you're seeing complaints, please continue to reach out for support. We need to get this clarified, and I look forward to seeing additional information. I appreciate the information that Esther Pat's already sent to us, and from Ms. Wyman, we'll look forward to seeing that legal standing too. I think it is important for us to recognize the harm, right? Like misunderstanding, not having clear answers from federal and state entities, it can be frustrating. And I hear that, but I think it's also important to think about the impact, right? So many people are already struggling just to find housing, and anything that can result in it becoming more difficult is something that I think we need to own, right? Those of us who were here last week for not pushing back more, not for not asking for more time and additional input. And I would like to see additional legal input on this, because I think it's really important for us to have that firm standing. And this is not a new ordinance. It's new for the state. It's not new for Urbana. And so making sure that we are able to provide the necessary legal standing so that when people are facing this discrimination that we've taken a very clear stance against for years, that people know that the city will continue to support them. That's one of the amazing things about Urbana. We're supposed to be leaders, right? Like the state is just catching up, and we shouldn't be making it more difficult for people to exercise the rights that they have. So thank you all for bringing this to our attention. And I would encourage us to continue this conversation in council as well, because not everyone who watches the township watches the council, and vice versa.
And you bring up a good point. It's not a new ordinance, but this town is never the same place twice. It's kind of like TJ Maxx. We have a lot of new landlords. A lot of properties have turned over lately. We also are a very transient community with constant new residents. So this is an opportunity, once we get this clarified and can very clearly, it's time to re-educate people. It's time to re-educate the entire community, and it's an opportunity to do so. James.
All right, yeah, thank you. Thank you for the comment. Thank you, Esther, for the emails and the additional information. I do think it's important that as we have this conversation that Lily Walton be here, because the Housing Authority is an important part of this conversation. She was able to answer some questions for me at the meeting on Monday. And now I wonder whether I heard her answers correctly, because she talked about the triangle of relationships created by these programs, and I heard very clearly that one of the parts of the triangle is the relationship between the housing authority and the landlord, which I heard was a voluntary contract that they enter into. And so I have to understand why that's not voluntary, right? I need to understand that better, because I need to understand why we believe state or local ordinance can compel when it comes to federal programs. That's the rub, and I'll need someone with legal authority to explain that to me. Sure, you can.
Sure, come on up. We have till 7 o'clock.
Is this live?
Yes.
Okay. HUD, the Department of Housing and Urban Development, as you know, is a granting agency. It gives you your home funds and and CDBG and all that. It also has a civil rights division that enforces civil rights laws. There is no federal civil rights law protecting against housing discrimination based on source of income, or sexual orientation, or marital status, or several other things are covered by state and local law. So, from HUD's point of view, and they'll say it a million times, and that's what Lily Walton was saying too, Section 8 is a voluntary program. But in more than 50 states, cities, and counties, local fair housing law prohibits discrimination, prohibits refusal to accept a housing choice voucher or Section 8 voucher. And so it is a voluntary program in the eyes of the federal government, and until January 1st of this year, it was a voluntary program in the eyes of the state government. And before 1979, it was a voluntary program in the eyes of the city of Urbana. And it goes back to a landlord can do anything they want except what a law prohibits. And so HUD considers Section 8 voluntary and probably always will until the federal government changes their laws. But any jurisdiction, state, county, or city that prohibits refusal to accept a voucher, I guess technically, as I said before, it doesn't make the program not voluntary, but if you don't participate, you're in violation of the law. And I don't know if that doesn't jive with you, but that's basically, it's not a federal violation, but it is a local violation, and now it's a state violation. And so in that sense, the program's not voluntary. Yes, Danielle?
Well,
want to add to that?
Or
you asked me again? Okay, go ahead.
So do we have support from the state on this? From the Attorney General?
We have support in two ways. Well, actually, the Attorney General will probably issue an opinion. In fact, last Monday I was thinking, am I important enough to be able to get the Attorney General to come here himself? And we might just do that, maybe even the governor, I don't know. But there are two ways the state of Illinois has told you that you have to, that there's landlords, that it's not voluntary in Illinois. One was in Illinois, that's not voluntary. One was the appellate court decision in Godinez in 2004, where in the city of Chicago and in Cook County, and they didn't mention it, but also in Urbana, where local laws prohibit discrimination based on source of income, including vouchers, it's not voluntary. That was, if you read the decision, that was the decision in Godinez. It's not voluntary. It had a sentence at the very end of the summary of the decision saying that there was the court did not rule on the question of whether it would be a choice to not participate if participation caused an onerous financial burden to the landlord. But in the facts of the case they were hearing, there was no evidence of that. And I would speculate that since there is no cost, the rent is the landlord gets the exact same amount of rent, and the contract that they have to sign with the housing authority, the HAP, Housing Assistance Program contract, is it's either 1 or 2 pages, and it is a recitation of what's in the lease. The purpose of the housing authority requiring the landlord to have a contract with them is the landlord is promising the housing authority that it's not lying about what the terms of the contract with the tenant are, because there were landlords who would set the rent for the fair market rent required by HUD, like the apartment will be $850 a month, but then they have a separate contract with the tenant for the rent to be $1,020 a month. And the HAP contract is a contract promising what's already in the contract, but there's not a single thing that HUD requires the landlord to do in the HAP contract that the landlord is not required to do in the landlord's own contract. For example, it says whether or not the landlord's lease says, it'll say which utilities are paid by the landlord. HUD doesn't dictate that. Housing authority doesn't dictate that. They just copy whatever it says in the lease. And that's its sole purpose. And that's really why I cannot stress enough how the claim that a landlord has to do anything other than sign the contract agreeing to the contract that they agreed to the tenant is a false claim, because there is nothing else required of the landlords other than submitting to the inspection, which they submit to when they show apartments. And actually, pardon me for taking more time, but there was some mention about, I was so angry, frankly, but something about the lease provisions. I think it was actually your question about prohibited lease clauses, or maybe it was yours. It was one of the two ends. There are numerous lease clauses that are prohibited in various places. In the city of Urbana, chapter 12.5, subsection 10, has a list of lease clauses that are prohibited in the city of Urbana. And I believe that list is more extensive than the housing authority's list. The example someone gave here, it was probably Mr. Evans, because I heard a male voice, it was one end, or it was Mary Else. It's the clause that says, a lease clause that says the tenant waives their rights under the law is unenforceable under Urbana landlord-tenant law. And there are also some state laws that impose certain mandates on landlords. Like if you are renting property that was built before 1978, the law requires you, even though it could be conceded, landlords will argue this is interference with private contracts, but Illinois state law prohibits you from renting to a tenant in a building that's built before 78 or older without giving them the lead paint disclosure information. That's specific information that has to be given to them. There's a state statute, 765 ILCS 735, that says no lease can require a tenant to pay for any utilities, or no landlord can rent to a tenant any place where the meter for the individually metered utilities to the apartment includes service to any area outside the apartment. And there's a penalty of treble damages, okay? So that's prohibiting what landlords can do. That's what laws do. And landlords push back against any laws because they believe, the organization believes as a matter of principle that government should not regulate rental housing. And that's really what you guys are up against. And the Section 8 thing is just one arm of the whole belief that government should not tell an owner of a private piece of property what they can do. And actually, the laws say they can. And I don't know, Ms. Walton even brought up the business about damages. Anytime anyone's talking to you about, you're talking about vouchers, and all of a sudden people start talking about tenants doing damage, that's bigotry. That's what it's all, and that's the proof, that's the tell, that it has nothing to do with business, and it all has to do with prejudice. They don't want to rent to, quote, those kind of people, end quote. And a lot of them will come right out and say so. In fact, when the city of Champaign was considering this matter in 2006, the property manager of Royce and Brinkmeyer Properties did a PowerPoint presentation for the council, arguing that statistically, Section 8 people aren't as good tenants as the general population, and that is why the law should not require people to take them. And I would just beg all of you, one last thing, since I've got the mic. Thank you so much for letting me have all this time. Anytime anyone says anything about Section 8, rewrite the sentence and replace it with disability, race, or children, or sex, and see if it still makes sense to you. Which is Danielle's point, when you were told that if someone just flat out refuses to even take your application, that's not actionable. Yes, if they said, I won't rent you because you have kids, or I won't rent you because you're black, that's actionable. If they deny it later and you have no proof they said it, that's lots of luck winning. But it is wrong to refuse to even consider someone just because of a demographic characteristic.
Thank you.
Thank you. Chandra.
So we heard that discrimination is difficult to prove. What's your advice or suggestion on how someone applying for housing can prove that they're being discriminated against?
I don't know how easy it is to prove, but here are the important things to do. Step one, and I've been giving this advice as long as I've worked at tenant union, do not reveal anything about yourself that might be the grounds for discrimination, which is why it's so hard for people with race discrimination. But even on the phone, if they can't tell what you are, find out. You call, is the apartment available? Yes. Ask, what floor is it on? Because that gives you the opportunity for them they might tell you, oh, we've got apartments on the second and third floor, so you know it's more than one unit. That won't always work, so they'll just tell you a floor. Then you go and you look at the place, and if you're interested, you ask for an application and see if they'll let you apply. And you don't tell them I have a voucher. You don't tell them I have children. You don't tell them I have a disability that you can't see. You just go ahead and apply and see what happens. And then if they don't accept your application, but you believe you were otherwise qualified, then you file a discrimination complaint with a place where you count on them not throwing it in the trash or burying it or delaying it for a year, which you can't always find somewhere. Well, we suggest if it's race discrimination, file with the federal, state, and local. If it's anything covered by federal law, file with HUD, the state, and locally. For years, HUD and the state have been together where you can only do one, but you try for all. If it's something only covered by Urbana ordinance, like source of income up until this year, you file with Urbana. And notwithstanding any problems here, if it turns out that City of Urbana is not a bad referral, then I would advise people to contact the City of Urbana Human Rights Officer and the state agency. When that happens, and that's if you get an application denied. And when that happens, then it is best to, of course, and the whole way along, you should keep all the information and document things, write down which apartment number you saw, so you have as much information as possible. The first step when it comes to human rights, or if they go to the township, or if they come to our office, is we'll call the landlord and say, oh, you might not realize the law doesn't allow you to just say no Section 8, and if the person's qualified, you need to take them. Would you please take them and see if they will? And, it depends on the case. We've had cases, I'll tell you, one thing I've heard a lot from clients is when a landlord expresses reservation about renting to someone, usually this is kids or disability, because they'll come right and say it. Well, this really isn't, well, we like to rent to wheelchair people only on the first floor, even though the building has an elevator. We had one of those. Often, the first thing the person should do is say, isn't that, you can say it real laid back, isn't that against the law? Whoosh, it's amazing how many landlords have backed down. I mean, over the years, the stories I've heard, especially with kids. Oh, I'm not saying I won't rent to the children, which is exactly what they just said. I just thought you might not like it for your children. And if that doesn't work, just saying, isn't that against the law? Then, again, you go through the complaint process and see if the landlord will back down when confronted with that's against the law. And I cannot give anyone any guarantee, but I want to say one more thing. Probably should wait till, I don't know who watches these programs anyway, but everyone you know and everyone who's a service provider, it's total bull. It's ridiculous and bogus to say, I can't file a discrimination complaint because I'm looking for housing. You don't have to choose one or the other, and service providers need to know this. If someone's been shopping apartments, they found a place with XYZ Realty, and XYZ said, we don't take vouchers. File the complaint that XYZ said they wouldn't take vouchers, and keep shopping. And sometimes XYZ will back down in response to the complaint before you find another place anyway, and then you get it. So the short answer to your question, Ms. Bishop, is it's really hard to prove discrimination, except the fact that many people who discriminate are stupid and make it obvious or admit to it, and that's the good thing. But when this law first passed, when it was first being considered, and council member asked, but how are you going to prove it? It's so hard to prove. I stand before you as a 67-year-old who's worked my whole life on this stuff. A large number of people will comply with a law just because it's a law, or when caught not complying, say, oops, I didn't mean it, and back down. And that is the main way the law works. And this obsession that people have about, well, unless we're certain we can win in circuit court, throw the case out, you shouldn't. You should push through as far as you can go, including if you lose in court, because then at least you fought for something that mattered.
One more question, Sharice.
You might as well stand right back up, Ladybug.
I don't know you, but I knew your mom on this issue and others, and yeah, what would you like to know?
Because it's weird. Past week, I have had to talk to 2 different people about issues regarding their housing. Not talking to one, emailing another. This does not. What you're talking about is not just regarding vouchers. This is tenant stuff. And one lady, I think I even gave her your mobile number. But I was looking, I was like, this is the person you need to talk to, because for sure I'm not the authority.
Sure, that's good.
But I do understand what you're talking about, because I rented when I lived in California, and yeah, I was not surprised with how sometimes the manager handled that kind of stuff, and I also had to tell him that's against the law, when I would run across him interviewing somebody. But the other thing is that I think it's important for the public to understand that although we're doing a lot of talking about vouchers and so on and so forth, that this is about apartment hunting, period.
Yes.
And I think it's just important for them to know, not just apartment hunting, but even house hunting, if you're renting a residence or whatever. And the most important thing, too, is that if you are renting from somebody, that you're renting a house, you need to make sure that they are registered with the city of Urbana, as we've come across quite a few people who aren't, I know in the past couple of years that were renting property and they weren't registered. And that is also an issue. And so I really would like for people to have that information. If if they call you or the tenants union, that may be another piece of information that has to be added to that particular thing, that if you are renting a house from or an apartment in or the city of Urbana, that person, that owner, is supposed to be registered with the city of Urbana.
Yeah, Ms. Hersey, I think it'd be absolutely wonderful if the city of Urbana would notify, every time someone new buys a rental property, would notify, when you become aware of it, would notify them of the rental registration ordinance and landlord, the whole chapter 12.5 of city code, which is the landlord-tenant ordinance, the registration, rental registration, and chapter 12 of city code, which is human rights. And also, if you have kids, it's not smart to call a landlord and say, I'm looking for a place for me and my kids. Just say, I'm looking for a place. Keep the kids a secret as long as you can, because that does appear to be the single most common form of housing discrimination out there. But like I said, a lot of people solve it for themselves by just saying, isn't that against the law? But yeah.
In the 2 minutes we have, can I provide 3 quick answers to the questions? So the first is the housing authority nor the township can compel landlords to participate. I think the use of voluntary by Lily is somewhat inaccurate, but the city is the only one that can compel them to participate. So the housing authority's relationship is with HUD that does not compel this, right? And the township does not have that authority. I've looked into it because I would like to have that authority, but I don't. Secondly, how do you prove it? Chandra, as our office has been asking for years of the city, you test. It's what the late Eric Jacobson used to do when he lived in Ohio, is he was a white tester to test for racial discrimination. It's been done before, and the level of discrimination in Urbana is such that we need to test, and I've been requesting that. It was one of the recommendations I presented to the Human Rights Commission, to the mayor, and to the council in 2018. The third is that to support Ms. Hersey, to support rental registration, we require that landlords are registered to receive rental assistance. We don't have to, but that's our support for the rental registration program. And by doing that, we ensure that people are registered. And if they do not register, then we report it to the city and we continue the rental assistance so that the tenant is not penalized because of the landlord's actions. But we do make sure and we check against that. There is a coalition meeting tomorrow, and if you're interested in speaking directly with Hope Fair Housing, let me know and I will send you the link. That's all.
Thank you. With no further business before the town meeting, this meeting is adjourned and we'll start up immediately with the council meeting. Thank you all. Okay. Welcome to the regular meeting of the Urbana City Council for Monday, March 27th, 2023. Will the clerk please call the roll?
Ms. Wu,
Here.
Mr. Evans.
Here.
Ms. Hersey,
Here.
Ms. Colacetti,
Here.
Ms. Bishop,
Here.
Ms. Wilkin,
Here.
Mr. Quisenberry,
Here.
Mayor Marling.
Here. Next item is approval of minutes from the January 23rd, 2023 meeting. Will
So
the-
moved.
Moved by Mary Alice,
Second.
seconded by Sharice. Are there any substantial corrections? All those in favor, please say aye.
Aye.
All those opposed? That motion passes. Additions to the agenda, I would like to request that we move item L, which is the appointment of a Community Development Services Director, up to under unfinished business. No objections? Yeah, it would, item L would occur after unfinished business, which there is none. Unfinished business is a standing part of the agenda, so. Or you could say before reports of standing committees. If that
I
makes
thought you
sense.
meant under,
Got it.
under
Got
unfinished
it.
business, like as if it was a point of unfinished business.
No, it's not, yes, yes. Okay, we'll move on to present.
One more, I don't see council comment and communication on the agenda, so if we could, I think it's usually under public presentations and public input for council meetings, right?
There's no discussion.
Yeah, there's no discussion item. It's not currently on the agenda, so I would just ask that it be
Absolutely.
put on the agenda.
So council comment. That's not. So after presentations and public input, we will have council comment and communication. And following that will be appointment. All those in favor, please say aye.
Aye.
All opposed? Okay. Presentations and public input, we have the 2023-2024 Annual Action Plan, and that will be followed by public input.
Good evening, everyone. Tonight, I will be providing a brief presentation on the city's 2023-2024 Annual Action Plan. This plan outlines the activities that the City of Urbana and the Urbana Home Consortium will undertake utilizing HUD funds through the year 2023-2024. This plan also explains how these activities will meet the goals, strategies, and objectives outlined in our consolidated plan. The annual action plan is completed annually, and this is part, as I mentioned, of the city's broader 5-year consolidated plan. Our current consolidated plan is 2020 through 2024. So this is first and foremost a planning document that outlines the goals and objectives for the city's 2 HUD grant programs, the Community Development Block Grant Program, or CDBG, and the Home Investment Partnership Program. The plan identifies the strategies that staff will pursue over the following year in order to address community needs. The city is required to complete this plan and submit to HUD each year. Another really critical component of this plan is community input. So as part of the annual action planning process every year, we do community outreach to get input on needs from residents. So in a bit, I'll be showing you where you can review the plan and find it on our website. As you start to look through it, you'll notice it's a pretty lengthy document, so I'm going to just highlight 3 really key areas of the plan here. So the AP 15 section, which can be found on pages 10 to 13, highlights the expected resources that the City of Urbana and the Urbana Home Consortium will receive from HUD for the year 2023-2024. The AP 20 section is the annual goals and objectives section, and this can be found on pages 15 through 19. And this section summarizes the specific goals that the city and consortium intend to initiate and or complete within the term of the program year. So in order for a goal to appear in our annual action plan, it must also appear in our consolidated plan. The AP 35 section, which is on pages 20 through 38 of the plan, this provides a summary of the eligible programs or activities that will take place during the program year in order to address those priority needs that are found in AP 20. It also outlines the strategy that staff will use in order to address those goals and objectives. So for the 2023-2024 fiscal year, the city and consortium have received our allocation from the U.S. Department of Housing and Urban Development for both of these grant programs. So for the Community Development Block Grant Program, the city will be receiving $498,343. And for the Urbana Home Consortium, we will be receiving $779,013. And I'm sure you're all familiar at this point, but the consortium includes the cities of Urbana, cities of Champaign, and Champaign County as represented by the Regional Planning Commission. So those home funds are available countywide. The City of Urbana CDBG funds are only available to be used within the City of Urbana. These allocations are relatively consistent from year to year. HUD has a formula that they use in order to determine the allocation amounts. Our CDBG allocation went down a little bit this year. Last year, I believe it was around $510,000, so it's decreased slightly, but the Home Consortium funds went up slightly, I believe, so pretty consistent from year to year. So the CDBG and the home programs, I'll just outline really quickly some of the eligible program areas that we can spend this funding on. And just a note about this before I start, these eligible categories are determined by federal statute. So we have to ensure that everything we're spending this money on is within federal statute and aligns with one of these eligible categories. So the Community Development Block Grant Program is a very flexible pot of funding that we receive. We can utilize CDBG funding for public service programming. For example, our Youth Services Grant Program is funded through the public service portion of the CDBG program. We can also spend CDBG money on public facilities or infrastructure improvements throughout Urbana, housing rehabilitation programs, blight reduction, or lead-based paint remediation. The one constant for all CDBG funding is that the funding has to go to benefit low to moderate income residents of Urbana. The Home Investment Partnership Program is a little bit more targeted. It's more specific. Home funding has to result in the creation or the sustaining of an affordable housing unit. So it's a little bit more targeted than the CDBG program. So home funds can be used for tenant-based rental assistance, which is also known as TBRA. We can utilize it for down payment assistance programs, housing rehabilitation, or the construction or development of affordable housing. So as I mentioned earlier, community needs and gaining input on community needs is a really important part of this process. So that's one of the reasons that I'm here tonight, is just to spread awareness of this plan and the need for us to really gain input from the community about how they want this money to be spent. These programs do really focus on housing and affordable housing, and we know as we look at statewide statistics that affordable housing is really a critical need. So I just have some information here that I think is important to consider. These numbers are from Housing Action Illinois, and they are statewide, but I think they do give a good indication of the affordable housing situation here in Champaign County. So statewide, we see that 71% of renters are considered severely housing cost burdened, which means they spend more than half of their income on housing costs. A minimum wage worker has to work 2 full-time jobs in order to afford rent on a 2-bedroom apartment. And only 36 of every 100 low-income renters looking to rent a home in Illinois will find one they can't afford. So again, these are statewide numbers, but I think it speaks really well to the situation that we see locally in terms of affordable housing. But we also know that there are other needs in the community, and again, that CDBG pot of funding, it is pretty flexible. We can use it on programs other than just housing. So, from the community in previous years, we have heard about the need for improvements in neighborhood infrastructure, whether that's, improved sidewalks, lighting, or drainage. We also have heard, community safety and violence prevention are very important areas that, we can continue to utilize this funding for. And then also public services. So whether that's youth or special populations, we know that there's a big need in the community to support programs that provide funding and opportunities for youth in our city. So I'll just go over briefly the timeline. So again, the draft annual action plan is available for review and comment. The public comment period began on March 1st, and it runs all the way through Friday, March 31st. I will be coming back before all of you, so this is not the last you'll hear from me. I'll be back on April 17th to present the final draft of the plan to all of you, and you'll be voting to approve it. Once it's approved and finalized, and once we've incorporated all of that citizen input, we'll be submitting it to HUD. The deadline for that is May 15th. And then we hope to have our funding allocations available beginning July 1st. So some of the outreach activities we have been engaging over the past month, we have been actively sharing the plan with community and advocacy groups. We've held 2 public hearings. We will be holding our 3rd and final public hearing on the plan tomorrow before the city's Community Development Commission meeting. So that will be here in council chambers at 6 p.m. So any resident can come and provide comment on the plan tomorrow at 6 p.m. here in council chambers. And then we also have sent out a community needs survey, again, just asking residents to let us know what needs they're seeing in their neighborhoods, whether that's infrastructure, housing, kind of what they're seeing and how they think this funding can go to address those needs. And when I'm back in April, I will be sharing the results of that community needs survey. So I'll have more information once the public comment period ends. So there are several ways that you and also residents can let us know your thoughts on the plan. Again, tomorrow, Tuesday, March 28th at 6 p.m. here in council chambers, we'll be having a public hearing. Also, the grants at urbanaillinois.us email address. Residents can submit their feedback through email, or they can just give us a call. That is also a great way to get in touch with us. Also, if anyone has an issue finding the plan or is not able to locate it, they can always give us a call, and we're happy to provide that. I will say it's available on our website in the community development section of the website, and there's also a physical copy at the city clerk's office and at the front desk of the Urbana Free Library. And that is all I have for you tonight.
Any questions for Braden? Chris?
You said thanks for the presentation. You said the funds will be available July 1st. And the figures that you gave us for CDBG and home is for 2023 and 2024. So when does the money have to be spent by?
So, so the grant cycle tracks the city's fiscal year. However, we do tend to have, carryover. We don't have to have it all spent, within the fiscal year. HUD does allow us to carry over from year to year if we have a balance, which we typically do have a balance. As we've come before you before, there is a timeliness question where HUD doesn't want large amounts of grant funding just sitting unused. They want to see that you're engaging, with the community and having good programs. So it's a couple years, but it's not, you don't have to have it all spent within that one fiscal year.
Good, thank you.
Any other questions? Okay, thank you, Braden. Oh, Sharice?
This can be found online, the draft of the annual action plan,
Yes. Mm-hmm.
Under community development or?
Community development, it is there. And also, anyone can email us or give us a call if you would like us to get you a hard copy as well, but it is on the website.
Okay, thank you.
Would you mind sending it out to council tomorrow, the link, so they can share it? Thank you. Any other questions? All right, thank you, Braden. We'll move on to public input. If anyone wishes to address the council, please step up to the microphone. Seeing none, we'll move on to council comment and communication. Chris?
Well, I want to thank Esther Pat, Danielle, Ruth Wyman for their presentation tonight during the town board meeting. I too was very disturbed by last week's presentation. I really, and I looked over what Esther Pat sent in the way of the appellate ruling from 2004 and everything. I am of the opinion that there is no ambiguity in the Urbana ordinance, human rights ordinance, and that the prohibition against source of income should absolutely be enforced. Thank you.
Yeah, thank you. Similarly, so for folks who might not have been watching the town board meeting that happened just prior to this, we had our township supervisor as well as a couple of experts related to housing in our local community talk about, provide their feedback on the presentation that we got from city staff last week about the enforceability of the housing discrimination related to source of income. And I think that it is important to recognize that we do need additional legal clarification. As was mentioned, Esther Pat from the tenant union provided a citation that would suggest that there's a very clear path in terms of enforcing this. So I expect to see a further clarification for the city council and the community. But I also want to make sure that people are aware that there are resources if they are facing housing discrimination in Urbana or in Champaign County more generally. And also to remind folks that not only has Urbana's ordinance been in place for quite some time, but now there's the statewide ordinance, and there'll be some educational opportunities coming up. So for Urbana residents, the Township Supervisor's Office phone number is 217-384-4144. For folks within the larger Champaign-Urbana community, the tenant union also is a resource that's available to people. Their phone number is 217-328-3313. And then there were two different presentations that are coming up about fair housing that'll be happening soon. The first is on Tuesday, April 4th from 6:30 to 7:30. And that'll be at the Housing Authority of Champaign County, Community Room 2008 North Market Street, Champaign, Illinois 61822. There's contact information for Nafia Khan for more information. Phone number 630-690-6500, extension 122, or Nafia, NAFIA.Khan, KHAN, @hopefair.org. That'll be the first of those presentations. Same contact information for the second and the same location, but that will be Wednesday, April 5th from noon to 1. I certainly plan to try to attend one of these sessions and want to make sure that I have as much information as possible, but I also want people to understand that there are resources. And at least myself, I believe other council will also be asking for further clarification so we can make sure we're properly enforcing our ordinance. Thank you.
Any other comments? Okay, thank you. We'll move on. Unfinished business, there is none. We'll move on next to an appointment. I'd ask Kimberly Smith and Sheila Dodd to join us at the front. Welcome. I'm very pleased to submit the following appointment for your approval. It's Kimberly Smith as Director of Community Development Services, effective April 3rd, 2023 through June 30th, 2025. Council members have received a copy of Ms. Smith's resume and cover letter, and I'll just read the bio that's included in this memo. Kimberly Smith is an economic development and planning career employee with extensive background, a passion for the work she does for the community. She earned both a Bachelor and a Master of Arts in Urban and Regional Planning from the University of Illinois at Urbana-Champaign, as well as an MBA from Bradley University. She began a professional career as a planning intern at the city of Urbana, where she also held her first professional role as a planner in the Community Development Department. She later moved to the city of Peoria, Illinois, where she spent over 20 years, eventually becoming a senior urban planner for community development. In this position, she managed regional planning goals, code enforcement, zoning changes, and economic development issues. Kimberly directly contributed to creating long-term relationships, planning, and project implementation for 3 challenged neighborhoods. This required her to gain resident trust and commitment from large-scale institutions and other commercial employers to successfully transform these neighborhoods. She also worked to support historic building reuse and preservation, code administration, economic development, and budget management. After her tenure in Peoria, she transitioned to her most recent role in the city of Bloomington, Illinois, as Assistant Director of Economic and Community Development. Her professional focus in Bloomington has been managing the building safety, economic development, grants management, building code enforcement, and urban planning divisions. Kimberly views the opportunity to serve as Urbana's Director of Community Development Services as a homecoming. And she's excited to contribute her skills, experience, and leadership to our community once again. I also wanted to make a note about the length of the appointment. As you remember, last year, council changed appointment rules to allow for 2-year appointments. So the other department heads are on a 2-year cycle, and their appointments will all end June 30th of 2024. They'll then be subject to a 1-year appointment after that because we don't want to go beyond all of our terms will end in 2025. So the next appointment cycle will be for 1 year. So I'm asking for an exception to the rule to allow Ms. Smith's appointment to be on the same ending date as, at any rate, for June 30th of 2025. So by the time we reach 2025, all appointees will be on the same cycle and ready for the next term for elected officials. And so I would ask for an exception. If you're not comfortable with that, we will go with a 2-year appointment, which would end on April 2nd, and then we'll just have to renew it in April 3rd, for beginning April 3rd of 2025. But I hope you can make an exception. Kimberly's certainly welcome or willing to answer a couple of questions. Sandra.
Hi, thank you, welcome. I have a few questions, but I'll take them one at a time and give other space. Appreciate your interest in coming to Urbana, and you have a very extensive experience, which is, of course, welcomed. How will you work to increase diversity within the Community Development Department? You have to press the button. Yes, in terms of staff.
In terms of staff. I guess there's a number of things. It depends on, I think when you are looking for who is going to become part of your staff, you don't wait until there's an opening in the staff. It's every interaction all the time. You are always selling. And had something like where I work now, just last week we had a group of students come over, and it was to see what we do, but we viewed it as an opportunity to sell the city. So I think that's probably the biggest impact you can have on encouraging diversity and getting diversity to apply. So again, just every interaction is really kind of a future job interview interaction. So kind of looking at it from that standpoint.
And remember, this is an opportunity. This is a general opportunity. It's not a job interview. We do welcome questions. No, I understand. Yeah, absolutely. Is any other comment or question from a council member?
What do you think is the biggest priority in community development currently, either from what you know of Urbana now, or, sort of in general in the regional community development space, since it seems like you've been sort of all over central Illinois?
Priorities. I think growth and enhancement are two of the biggest things to look at. I think one thing that's nice about the community development department is we kind of work the circle of all of the things that contribute to having a nice place to live, a nice place for businesses to thrive, residents to have an income. So if you think about all the different things that we touch, from building safety, we have safe buildings, and an easy process for development to occur. There's grants to help those in need, economic development to encourage, again, more, to help the business that we have, to encourage more to come, thinking bigger and bigger. Planning puts it all together. It helps lay the groundwork. It looks at everything from infrastructure to how everything literally fits together, from making room for emergency services to just like say tying every type of strategic plan back together. So those key things, I think all of that really contributes to being proud of what we have, seeing what we can build on in the first place. I think there's some economic challenges that the city's seen. I've got fresh eyes on the city. I've been back. I've peeked in over the years, but I can very clearly remember, years and literally decades ago. So it's easy for me to see a progression of where things were, where they've ended up. So I think there's a lot of opportunities to renew in terms of historic preservation, and that speaks to affordability. It speaks to sustainability as well. I think there's a lot of growth doesn't necessarily mean changing borders. It just means back to increasing tax base, making it easier for those that live here, and just economic opportunity for everyone. So attraction, like say, of something larger as well, and just truly setting the stage comes down to those two things.
Grace.
Thank you. I was wondering if you could tell us just kind of a summary on an example of the transforming challenged neighborhoods in some of your past work, particularly if any of them emphasize a focus on equity.
On equity. Yeah. There have been a number of things that I was specifically speaking of Peoria. I've been in that for a very long time. It was almost 21 years. And so over time, we had a number of different projects. We had, there was a focus on the South Side, and the South Side was an area that started out, I'm talking 1800s, like workers' housing. And then over time, as industry went away, and then those of means, quite frankly, moved out, and who was left behind, you had a lot of highly impoverished, you had single mothers, you had challenges from that level, and then you had those that just kind of dug in and stayed because they loved their neighborhood. And we did one of my favorites was essentially a corridor study, but it was basically an economic revitalization of what are we going to do with one of these corridors? How are we going to bring in actually quite literally developer interest in building in an area where the numbers just don't pen out at all. So how do you get that to happen? And how do you promise that to residents that over time have been promised over and over, hey, something's going to happen, something's going to happen. Oh, we've seen this before. So in that example, it was kind of getting real. Like if we had started out with student projects and kind of progressed all the way to, we had an architectural firm just draw what it could really look like and set those expectations. Starting with student projects, it was a little too exciting, and we got a lot of, am I on? Yeah. We got a little, okay, when's that going to happen? That's an idea. But then when we went all the way to the architects drawing a real plan that brought in, here's where you can have a job, here's where you can have workforce, here's where you can have a place where you can, a shared living environment that's got daycare and shared cooking opportunities and that sort of thing. So the gaining trust was over time, just working with the right officials, residents. Some of that took, for another project, it was actually several different neighborhoods, door-to-door surveys, and just showing, hey, we care, we're out here. Beyond surveys, just at every meeting, having, just getting to know them, becoming, as much as you can, part of that, the neighborhood, and understanding what the real issues are. Not, I'm just staff that's just here, and here's another plan. It's showing how can we actually make these work, and then also bringing in investors, large organizations that needed to have a focus. So some of those things that we talked about, or that I just mentioned, involved, a healthcare facility, and things that you needed others from other parts of the city to care and actually make that happen. What I'm speaking of all kind of culminated right before COVID, and then in the middle of COVID I left, so I can't speak to, in the end, how it turned out for all of that. But through the years, building up, probably went on kind of a long time, but it's exciting, and it's hard to pick one thing, and it's hard to push it all into one comment.
I had a question maybe more for the city side. If you could help us differentiate economic and community development, since those are separate departments for us here, correct?
Economic development is a part of the community development department. It's a division.
Oh, it is under that. And so what would be, I guess, so under community development and then economic development's a piece. If you'd help, like, what are some of the other pieces under that umbrella?
Sure. There's economic development, planning, building safety and code enforcement, and grants.
Thank you.
And I will say that's one of the things that Ms. Smith was a reason she was a standout for us, was her experience in departments with almost this very same structure and experience in all these areas. And when you're in a smaller department like ours, you have to wear many hats. And we, look forward to utilizing her experience in her previous positions. And we've got time for one more question. Sharice.
I don't have a question. I just want to say welcome, for one thing. The other thing, my ward went to a grocery store. Okay, and I've been saying this for years. We went grocery store, went bank branch of some kind. We need essential services in my ward. So, and I mean north of University Avenue and west of Lincoln Avenue, thereabouts. So I would appreciate anything that you can possibly do to grow and add growth, revenue, so on and so forth, to my ward.
I'll take her on
I'm
a
first
tour.
in line.
Yeah. I'll take her on a tour, Sharice.
Absolutely.
All right.
All right. I would appreciate a motion. Sharice.
I would like to move for the appointment of Kimberly Smith as Community Development Services Director to be our Community Services Development Services Director from now until 2025, actually, so that we can try to have that even up. That's my motion.
April 3rd, 2023 through June 30th, 2025.
Yes.
Okay. Is there a second?
Second.
Further discussion? Well, Chandra?
The city has been working a lot lately on doing things with the lens of racial equity and inclusion, and I hope that you will be taking that lens through this position as well, if you're appointed.
Grace?
Definitely agree and echo what Councilmember Bishop has been saying here. And yeah, in general, I'd love to see more diversity in leadership and stuff. I'm not part of the selection hiring process, so I know there's more detailed stuff that we're not a part of. But in general, I definitely am supporting more diverse recruiting and hiring, and hope that we can incorporate that into the city operations for sure. Thank you.
Any other discussion? Will the clerk please call the roll?
Yes.
Mr. Evans?
Yes.
Ms. Hersey?
Yes.
Ms. Colacetti?
Yes.
Ms. Bishop?
No.
Ms. Wilkin?
Present.
Quisenberry.
Yes.
That motion passes. Thank you. We'll move on to reports of the standing committees. Councilmember Colasetti.
On behalf of the Committee of the Whole, we have 2 items on the consent agenda for approval. First is Resolution Number 2023-03-014R, Supplemental Resolution for Improvement under the Illinois Highway Code State Motor Fuel Tax for Boneyard Creek Crossing Bridge Repair Design, and Resolution Number 2023-03-015R, Supplemental Resolution for Improvement under the Illinois Highway Code State Motor Fuel Tax for Savannah Green Alley Rehabilitation Construction. Recommending for approval.
Second.
One second.
Moved by Jaya, seconded by Sharice. Will the clerk please call the roll?
Ms. Wu,
Yes.
Mr. Evans?
Yes.
Ms. Hersey?
Yes.
Ms. Colasetti?
Yes.
Ms. Bishop?
Yes.
Ms. Wilkin?
Yes.
Mr. Quisenberry.
Yes.
Motion passes.
And then next, we had ordinance number 2023-03-006, an ordinance amending Chapter 21 of the Urbana City Code pertaining to land development. And I know we had some questions. Looks like John Zeman is coming back for us.
All right. Well, good, good evening, Council. We'll say we made our attempt to respond to your questions and comments over email.
Speak up, John.
Yeah, I'm sorry. We responded to your questions and comments about the Land Development Code by email and by including some revisions in the council packet, along with a 2-page summary of revisions and supplemental information. And hoping that council's gotten a chance to review that. I guess I'd entertain any questions that remain, any other concerns council has.
Mary Alice.
So thank you for making the updates and for sending a summary. It's nice to be able to see 2 pages instead of how many pages? 63 pages. I did go through it again a couple of times. And I had emailed you a couple of questions about PUDs, and Kevin, I think, is back there, hiding back there. Oh, you're hiding over there. Sorry, that's Tim over there. Had responded in terms of the PUD. So just for some background for City Council, this document only pertains to PUDs in the EJT, not within the city. So my question, which I understand, which makes a lot of sense, but you know, one of my questions was, what happens if a developer buys up a portion of a block and demolishes all the house? Well, now they're quote-unquote developing land, right? So I don't know if it's appropriate to state that for any PUD within the city limits, this land code doesn't apply to them. That's my understanding based on what Kevin said in the email today. Am I understanding that correctly?
Okay, there we go. No, so the PUDs are regulated by the zoning ordinance, but they are also considered development according to this code. So if there are parts of this code that apply that aren't covered in the zoning ordinance under PUDs, then the developer would be subject to those, is still subject to the land development code. So they.
Okay, so my question was, in terms of a minor development, I believe, my memory serves, it was 5 parcels or fewer was a minor one, which I think could be quite common with PUDs, right? And so that's why I was trying to figure out, how does that intersect with the PUD, all the information about administrative review? They do not go to the Plan Commission unless there's, unless they don't agree at the administrative review, right?
Yeah, that's correct. But the PUD process laid out in the zoning ordinance, essentially, it requires the same things that development require under the Land Development Code. So everything that the code requires of a minor or a major development is built into the PUD process already. It's just administered through the Plan Commission and City Council under that separate PUD
Okay.
section of the zoning ordinance.
So then, just to summarize, this land code does apply to PUDs within but it doesn't overwrite the PUD requirements in the zoning ordinance. The PUD requirements in the zoning ordinance required to go to Plan Commission and then to City Council for approval.
Right, and we tried to clarify with these revisions. We tried to sort of strip out anything that would be confusing. So that's why we took, for instance, the definition of planned unit development, and it actually had some things in there that kind of defined them. But in this version, we just said PUDs are defined in the zoning ordinance. So it will direct people there, so they know that's where it's dealt with.
Okay, all right, thank you.
Any other questions? Is there a motion for approval?
I'll move for approval ordinance number 2023-03-006, an ordinance amending Chapter 21 of the Urbana City Code pertaining to land developments.
Second.
Moved by Chandra, seconded by Sharice. Further discussion?
Thank you very much to staff for a tremendous amount of work, and this is a very hard and lengthy process, and I appreciate the work that went into this. I'm hoping that what I got out of our talks individually with staff was that this new plan will provide clarity to the developers as to what the expectations are, the building expectations are in Urbana, and that clarity provides, an easier process for them to build and develop in Urbana. So I'll be voting for this because I'm hoping that's what happens.
Any other comments? Will the clerk please call the roll?
Ms. Wu,
Yes.
Mr. Evans?
Yes.
Ms. Hersey?
Yes.
Ms. Colacetti?
Yes.
Ms. Bishop?
Yes.
Ms. Wilkin?
Yes.
Mr. Quisenberry?
Yes.
Motion passes.
The next item on the regular agenda, on behalf of the Committee of the Whole, was resolution number 2023-03-016R, supplemental resolution for improvement under the Illinois Highway Code State Motor Fuel Tax for Springfield Avenue from Wright Street to McCullough Street resurfacing design and construction.
Is there a second?
Second.
Moved by Jay, is seconded by Chandra. Discussion. Mary Alice.
So I believe this is the one where I asked and said which projects were going to be delayed because of this. And Tim's hiding back there now. If I remember correctly, you said something about Illinois and Kohler, is that right?
When we talked after the meeting last week, just looking at the existing capital improvement plan, those are the two projects within this fund that are the furthest out. They're in year 5 of our current CIP. So if we stick with the standard prioritization process that we've worked for other projects, those would inherently be the most likely, as discussed. I think John's looked in this a little bit more, though.
Yeah, and I pointed to is the Kohler Avenue project there from Green to Maine, which driven largely by the bridge that's in poor condition. And just when I sent the email out to council last Friday, I believe it was, just to note that, if this Kohler Avenue bridge needed to be delayed another year because of these funds increase, it poses the kind of risk it poses to the city is that most likely of, say, increased weight restriction, say reducing the amount of traffic and travel over it, which is a fairly lightly traveled bridge as it is. So not a great risk to the city if we have to delay that project.
I just know that we actually, I think it was over the Boneyard Creek, there was a bridge that was crumbling that we had to reprioritize, right? We had to bump it up the list because of, it was dangerous. Okay, all right, thank you.
Questions? Clerk, please call the roll.
Ms. Wu,
Yes.
Mr. Evans?
Yes.
Ms. Hersey? Ms. Colacetti?
Yes.
Ms. Bishop?
Yes.
Ms. Wilkin?
Yes.
Quisenberry?
Yes.
That motion passes. Thank you, Jaya. Reports of special committees, there are none. Reports of officers.
I'd just like to ask Dave Wessner to give an update on the research he's done into the Crisis Pregnancy Center issue that was presented about a month ago.
Yeah, thank you. And I'll kind of give, at least a brief update as it kind of sits today. As I commented at the last meeting, indicated there was a U.S. Supreme Court case that touched on the idea of what I would classify, and I think I said at that time, was government-compelled speech. That indicated that what was proposed would be declared unconstitutional, and I did check to see if there was any changes to that, and I didn't see any. What I would offer is that case was from 2017, and if you think about a 5-year period for the U.S. Supreme Court, not a lot of time in terms of maybe a change of makeup and a change of decision from a prior case, so I wasn't surprised that there maybe wasn't anything currently, but I did want to check just to make sure that, there wasn't anything else out there that might play into that. So that kind of currently stands as it is. What came up during the meeting was some thoughts about special use permit, and then the reality, I think, of the discussion centered on deceptive practices. What indicated briefly during that meeting was, in terms of the general concept of zoning, just saying that we don't want this kind of business to locate in the city, indicated that you can't really zone things out of existence. And so I just wrote down a couple of examples where courts have said you really can't just zone these out of existence. And I had mentioned adult uses. That's the easiest example, I think, that people were really hot on quite a number of years ago. But I found some others that I thought were actually kind of strange that communities did try and take this step, which were mobile home parks and daycare homes, where they tried to zone those out of existence in their communities, and the courts have said, no, you really couldn't do that. So as a general zoning proposition, that's kind of where that sits. In terms of the idea of special use permit, again, understand that's kind of a different concept and thought about maybe if we just make them get a special use permit, maybe there's some things within that dynamic that might be able to impact it. And I think in previous discussions for different kinds of things that happen relative to special use permits, I've indicated that if you think about zoning and even special use permits, it's outward facing. To a degree, you do look at the operation inside the four walls, but only to the extent of how it impacts kind of the neighboring properties. And so, I don't know that special use permits really get to kind of the point of the discussion in terms of the actual operation within the four walls of this kind of business to say, we can structure it this way to prevent what we understand to be, a problem by them. And so I don't know that that would be useful in terms of really getting to our point. And so what that leaves you with is deceptive practices, at least from the previous discussions, and I'll just say it at this point, I'm always open. Any thoughts, in terms of, oh, would you think about this? Let's think this through kind of concept. I'm always open. If there are other thoughts after tonight, even just share them with me, and I can certainly think about those, kind of walk through a path of that to see if there might be a path in terms of impacting, I think, the nature of the discussion. So in terms of deceptive practices, the city does not have an ordinance that regulates the idea of deceptive practices. I'm not sure many communities do. I will say I didn't go out and do a search of a lot of communities to see if they did or didn't. So I would be a little surprised if a lot of communities did. In the nature of what that really gets to, and I think Councilmember Quisenberry commented, I think at the last time, is if you think about the nature of this kind of entity that's located throughout the state of Illinois, that the Attorney General's office has an arm of it that deals with this kind of concept, either as a standalone business or as a group of entities that are similarly situated, can step into the idea of, if there are deceptive practices being utilized by them, has more of a capability, I think, to address that concept. And certainly, City of Urbana is probably not the only location, again, that these kind of locate. So you think about it, it's kind of a statewide perspective on that. And, the Attorney General's office may be a good mechanism to at least contact and say, we're concerned about this and we would like to step in and address that, to get their viewpoint and thoughts about whether or not that's something they've dealt with maybe. and see what the response and ultimate result has been. Or if not, ask them if there is a possibility of stepping into that, whether that's a direct contact with the Attorney General's office or through our state legislators of saying, we believe this to be a problem. Has the legislature even thought about this concept before? And you know, is there any path that they're considering in terms of addressing what ultimately seems to be the issue, which is literally just the operation of that business itself? I think, again, as Councilmember Quisenberry, and I apologize for keep commenting about him, but he's correct, too, in that the issue related to this is the fact that they're unlicensed. I mean, they're not a healthcare facility that's subject to a license by the state or anyone else. And that makes it difficult to step into regulation. When you're licensing things, there's possibilities of doing some regulation, whether it's a large extent or a small extent. Licenses make it easier to do that. If you just think about liquor licenses issued by the city, you know, those license holders can be regulated to a certain extent because we license them. And so we should be able to kind of look at their business and make sure that they're doing some things properly. And so, you know, that's where I think here is, you know, potentially a little bit of, got to put the thinking cap on this one because they're just not licensed. In order to address the actual operation, that's kind of where these kinds of things land. So again, just a quick update. Again, always open to thoughts and suggestions about, well, let's think about this possibility and just kind of walk that through and see.
Chris?
Thanks, Dave. First question, when you define zoning out of existence, does that mean prohibition, you can't come to our city?
Yes.
Okay. Second question, on special use permit, there is the concept, as I remember it, injurious to the general welfare. And I don't know enough about these pregnancy centers to suggest there is an injury to the general welfare, but could that concept somehow apply?
I think I get that's a good thought. You know, in terms of zoning, I'm always thinking about the idea of that generally is driven by injurious to the public health, safety, and welfare in terms of who's located around that facility to say, am I injuring it? And I understand what your thought process here. I'm just saying is, in general, that's how zoning looks at it. If we're thinking about the idea of that concept being more broad in terms of a community-based thought process of it's impacting the health of the community in terms of those individuals who may need to seek those services, yeah, we can certainly think that through and see if there's anything that you know could be relative to that. The problem is that those special use permits and those conditions are driven to, you know, more so, again, like I said, the conditions of how do I impact just around my four walls in terms of, you know, completely outward to the entire community. And so I would want to look into research and see if communities have even thought about that concept before, is how broad can you actually get in terms of a spectrum of a condition placed on a special use permit.
Right, and what's happening inside the building, is that harming people that go to that building? That's what I'm...
Yeah, and I kind of recall, we touched on that a little bit in terms of the jail expansion. I don't want to touch on a hot topic. I know it stirred strong feelings. And that's why I said earlier is that to a degree you look at the operation inside the four walls, but only in the sense of how does it impact the neighboring properties around it versus what's happening inside the four walls that affects the people that actually go inside the four walls on that. And that's where it's a little bit different. I've not run across that kind of concept in dealing with a condition on a special use permit for in that context of a very broad spectrum of, you know, impact.
Last question. There is one of these centers in Champaign. Did you look at what's going on in Champaign and what are the...
I didn't get that far. I can
Okay.
certainly see, again, and even see if they've got anything in their codes that actually even speak directly to this and what they may do or not do. So I can reach out to them.
Grace?
Thanks for looking into this and following up in our agreed upon timeframe. Definitely appreciate that. Sounds like maybe haven't seen the proposed state bill, House bill on this. I just sent a link to you two to see some more on that. And some of the community groups that have been involved in some of the research and presentations also highlighted this to my attention and are interested in some more follow-up. So I appreciate the offer and openness to hear more and continue the conversations because I think they'll have some input on that as well. So again, I sent that information. And I'm also curious about home rule allowances, that as a home rule municipality, what rights do we have as far as a standalone ordinance like our human rights ordinance and discrimination? It seems like we have the authority to set those kinds of fees under the home rule. And so I don't understand all the nuances, but I would definitely appreciate looking into that. And if you could send some things in writing, the Supreme Court case that you mentioned and some of those concretely in writing so that we could have some more information.
Mary Alice.
Thank you for the continued conversation and thoughts about this process. One thing that kind of struck me as we were talking, you had mentioned that these types of facilities aren't licensed, so it's difficult. So my question is there anything stopping the city from requiring a license? We require taxi drivers to have a license.
You can certainly, again, appreciate the thought about the ideas I touched on. I figured that may be a point of conversation for tonight as well. And I'm not making an assumptions or just a thought process about the idea of tax cabs. My experience for tax cabs is more so because you want to do a background on the drivers, and the reason for that is you actually are containing an individual inside a vehicle that you're in control of, and the idea behind those was more driven to doing background checks to prevent injury to the people that are actually contained inside, the cab. Understand maybe the thought process, let's expand it to a building, I suppose, too, in terms of how you would approach the idea of, licensing this kind of entity, I suppose. And so, yeah, again, just we'll think through the idea of what that process would look like to license this kind of specific business.
Any other thoughts? Thank you. Please.
Okay, I guess the way from what you were saying before, what I gathered is that this is definitely a hard bone to chew, based on the fact that all of this particular type of business is more based on a belief system and one's opinion or one's thoughts of what's good or what's bad, which also goes on to imply a person's freedom of speech, belief, so on and so forth. Because we don't license, we can't license a person's what they believe and so on and so forth. That's that whole double-edged sword thing with the Constitution. One person's freedom fighter is another person's insurrectionist and so on and so forth. And I hate the idea of a misinformation business being in our community. At the same time, I know that there are freedoms that everybody has, and just like we don't like that freedom, and you have people that picket and harass people that going into Planned Parenthood and so on and so forth. Guess what? There's another side to that too, where folks can do the same with those businesses and inform the public that there is some deception in their practices. And I don't think that would be against the law or against the Constitution, which we are taking oaths to uphold. Can you tell me if I'm right, wrong, thinking, or legally? I'm going to think what I want to think, but legally, on a legal track, is that a step that can be taken?
If you're talking about the picketing concept, I think the answer to your question is yes. It's no different, as you've said, is I suppose this is not going to come across well probably, but turnaround's fair play. I mean, it used to be picketing was the province of unions. They love to picket the potential employer, potential business who didn't use union labor in terms of their construction. But there are other situations that you end up seeing picketing, and this is one of them. And I think that is just because one side doesn't mean the other side can't. Picketing, I think, is kind of a long-standing tradition, I suppose, if you say it in the United States about the ideas. If I don't like that and I get a group together, we're going to go over there and put up our signs and, pound our fists, against what the operation of that business is. And so, yeah.
Do you have any idea how Champaign is handling this? Because my understanding also is that they have not one, but two of these particular entities in Champaign. And someone came knocking on my door just last week to sign a petition regarding that. And I was like, I really don't know how to handle this.
I don't, and I appreciate the question earlier, too, I think from Councilmember Evans on the idea of maybe touching base with Champaign, because they already have one, and maybe they've kind of stepped into this arena already and have dealt with it in a certain fashion. I guess I have not seen anything publicly, and if I missed it, I suppose. But certainly I plan on reaching out to the attorney's office in Champaign and just saying, hey, look, this is obviously a topic of discussion here. We know that there's one or multiple located in the Champaign area, and get their thoughts about what they've done or not done in relation to what the discussion is centered on for those kinds of entities.
Okay, thank you.
Jaya?
Yeah, thank you. And thank you for the update. I was going to bring up the same thing Grace did about the current Senate bill. There also have been a few attempts in the House that I think didn't pass. So I'd be curious to see kind of what happened with those two. It might be instructive to see what's happened on the state level and what's happening right now around this question. And I think, as this applies to whatever people might believe in terms of access to reproductive health care, I think it's important that we're talking about deceptive practices, right? And so I hear that, right, of their questions of, what does it mean if you're picking a side in terms of an issue, which I think it is really important that we're having conversations about reproductive health care right now, especially, but I think this is different, right? This is not just talking about protesting or picketing. This is people who are presenting themselves as authorities who are misleading people at a very, very vulnerable time. So, I would just reinforce the importance of looking at what's in the works on the state level, because it might be really instructive in terms of what challenges might be out there, both in terms of the current one and whatever happened with the previous ones.
Any other comments? Thank you, Dave. If we have one item of new business, which is resolution number 2023-03-017R, which is a resolution authorizing execution of an intergovernmental agreement for residential electronics and household hazardous waste collection. Scott Tess and Courtney Kwong.
Good evening, Mayor and Council. I'm Scott Tess, Sustainability and Resilience Officer for the city. I'm joined by Courtney Kwong, Recycling Coordinator for the city, and I'm going to turn it over to Courtney to summarize this agenda item for you.
Good evening.
Courtney, can you turn on your mic and speak into it?
Yes, good evening. Since the early 2010s, the City of Urbana has partnered with Champaign County, City of Champaign, and Village of Savoy to conduct semi-annual electronics recycling events. And in the past 3 years, we've conducted annual household hazardous waste events. We are bringing forth this intergovernmental agreement, which is really a cost-share agreement based on population, to conduct the electronics and household hazardous waste events collection events this year. The Urbana cost share is 18.6% of total costs, with a maximum total annual spend of just over $9,000. And I just want to note that these funds are already allocated in the use cycle budget. So we are seeking approval of the 2023 intergovernmental cost share agreement for the electronics recycling and household hazardous waste event collections for this year. Thank you, and I'm happy to take any questions you have.
Any questions for Courtney? Chris?
First, a comment, this doesn't happen enough. I mean, we need to be, I mean, my basement alone, we could be doing this every week. But I guess, where are we at with do we need a permanent facility? I think we invested American Rescue Plan's money, partial funding toward a permanent facility. Where are we, do you know anything about it and how likely is it to happen and all that?
The Champaign County Environmental Stewards, which is a nonprofit organization, is kind of taking the lead on that right now. And I think there's a very good chance, I think they've kind of identified some properties that could be potentially used for a household hazardous waste collection site. And so I think it's becoming more likely that we can have a permanent site, hopefully in the near future, based on, I think they just have to, we got some funding from ARPA, and I think they're securing some other funds, and hopefully we can move forward in that direction. And that's kind of one of our goals that we've been having for quite a number of years.
Okay, so is this event going to be out at the Parkland parking lot again, or where's it at?
Yes, the electronics events will be at Parkland this year, Parkland parking lot. And then the household hazardous waste event is going to be slated for State Farm, their parking lot.
Questions related to this resolution or this agreement? Grace?
Trying to think if this is a question. I'm just going to say it. I agree with Chris's thoughts on the cost and definitely needing more of these more regularly. And my understanding too is that they do max out. These are really popular events. They get full. I don't think I've even ever made it to one. It's like full already by then. So yeah, I've just got the years of old electronics piled up. And definitely agree the need for the permanent facility. And again, disclosing being a board member of the Champaign County Environmental Stewards and that plan's still going. And I think one of the options would be a cost share with the municipalities. So also from the city perspective, thinking about how much we're paying for these one-time events and, how much would it be a contribution to have a permanent facility. And, my anticipation is that will be, less cost per availability to the residents to have a permanent one than some of these one-day events that take a lot more setup and work and taking down and just kind of different than a permanent place. So I agree with that concern, and I'm sorry, it turns out it wasn't a question. Thank you.
James, question?
Yeah, thank you for this. I'm very supportive of this. One thing I always asked Susan Monty when I was talking to her about this for the Champaign County is with regard to the electronics recycling, what is the current landscape for some of the scrap and recycling private companies for taking on electronics recycling right now?
You mean locally or just
Speak
in
into the
general?
mic,
I'm
please.
sorry,
Yeah,
locally? or-
locally, historically, there have been a couple that would take certain kinds of electronics recycling, just drop it off. If it things like TVs, they might charge extra for if they were particularly large items. But there's always been a pretty healthy number of choices for certain kinds of electronics that if residents have them, they could drop them off anytime as opposed to the focused recycling event.
That is correct. So we have listed on the U-Cycle website several retailers and businesses in the Champaign-Urbana area that take different electronic devices year-round, like computers and monitors and printers and cell phones and things like that. I would say that the hardest item to recycle at this point are televisions. I think Best Buy is the only place, if I can say their word, but they're the only place locally that will take TVs, but it's a larger fee. I think it's maybe $25 to $50 depending on the size of the television. So it's pretty costly to recycle. So for these events, I would say about 75% of what we receive, 70 to 75% are televisions because that's the biggest need at this point in the community. So if we did have a drop-off in the future, that would be very helpful because we mainly collect a lot of televisions at these collection events.
All right, thank you.
Any other questions? Is there a motion?
I'll make a motion.
Okay.
I move approval of resolution number 2023-03017R, a resolution authorizing execution of an intergovernmental agreement for residential electronics and household hazardous waste collection.
There's a second.
A second.
Moved by Mary Alice, seconded by JF. Further discussion? Oh, James.
Yeah, I want to say that I do support these events, because I think even though it's prohibited, I think some of these things find their way into the waste stream anyway, and they're not supposed to. These events get people interested, they get excited, they take their stuff, that's great. I did ask about the other alternatives, because I want people to understand that there are other ways to get rid of your electronics in a safe and approved way. For the hazardous waste, it's absolutely necessary. This is why I supported that for the ARPA fund, because we need a permanent way to get rid of those things longer term. Thank you.
Further discussion? The clerk, please call the roll.
Yes.
Mr. Evans?
Yes.
Ms. Hersey?
Yes.
Ms. Colacetti?
Yes.
Ms. Bishop?
Yes.
Ms. Wilkin?
Yes.
Mr. Quisenberry?
Yes.
That motion passes. Next item, this discussion is kind of an errant item on the agenda. So the appointments have been done, and there's no further business before this meeting. We are adjourned.